there are countless people that are looking for one for me, but again, I'm going to leave it on mute for a while.
All right, Rita.
Good morning. 31st, the last day of August. Some might say the last day of summer. We've had a few things happen that require some updates. We've got 2 new executive orders. One deals with, of course, our educational system and approving essentially a hybrid system and other variations of in-person and out of school learning. Please, if you have children, that might be an interesting read. That are in school right now, that might be an interesting read. And then, of course, there was an executive order issued on the 26th. I believe that was Wednesday, on the voter registration and absentee ballot process. So those that are interested in that too, please go ahead and take a look. Now, the other thing that came out was just on Friday was a change in the phased-in plan for the judicial branch. For those that haven't had a chance to see it, it essentially just moves the date for phase 4, i.e. the beginning of phase 5, to November. I just had it here.
9th.
November 6th. And see, before it was going to be like in September, then it got moved to October 19th. Now it's moved to November 6th. And recall that during phase 4, which we're in right now and will be now until November 6th, there aren't going to be any small claims hearings, foreclosures, disclosures, or land use violation cases. So it pushes us out some more, and hopefully when phase 5 starts, we'll be able to, have some jury trials too. So if you do have questions about how phase 5's new start changes things, please forward them in, and we will work on getting some answers for you. One of the things I wanted to do too, which is just a tiny bit off script before we introduce our guests for today, is I just wanted to let you know that we had our August 26th kickoff. I think it was the kickoff for the judicial branch too, related to electronic filing. And there were some high points I just wanted to touch base with you on, so that you could be prepared for what comes next. And there will be other trainings available. One of those things was that you will be required, depending on what case you're going to e-file, and this is just something, these are just takeaways that I kept in the back of my mind about how maybe my practice needs to start changing, is that you will be required to redact some information. So when you, and if you look at the rules for electronic filing, which have been published, and that was relatively recent too, you will also have them amended, I'm sure, in short order as well for other types of cases, but they do address civil cases, criminal cases, and family cases right now. And one of the things that you'd have to do if you're submitting documents that have personal identifiable information is you may have to redact them. So that's one of the things you need to keep in mind. The other thing is there is going to be some sort of expectation, both from the professional responsibility side as well as the e-filing of documents side, to omit metadata. You know, like when we revise documents, when we send them to other people to have them look at it, they might amend, revise, comment, otherwise, anything like that. Your document collects metadata, and one of the things that is the goal of the electronic filing system is to eliminate the metadata that gets e-filed. Also, you will not be allowed to serve complaints via the electronic filing system. We're still going to have to do that the old-fashioned way. And that there is, if you go to the judicial branch website, there's actually a link called eCourts now, where you can click on that link and get up-to-date information regarding e-filing, like some of their purely training dates. You know, they've established dates that I think might only have like training for like an hour in hour blocks of some sort that will start in September, where you get like as much hands-on as you can think of via the Zoom or electronic means on how to start the filing process. Let's see what else we had here. Those were the real big takeaways that I got from the presentation that was just 2 hours long on Wednesday. All right. So with that, we now have a couple speakers that are joining us. Chet Randall, who is the Deputy Director for Pine Tree Legal and has been with Pine Tree Legal for about 17 years. And also joining him will be Erica Veazey, who is the Managing Attorney of the Bangor office and has been with the Pine Tree Legal for 13 years. And they're going to talk to us essentially about how the courts are being affected with the evictions and FEDs and the ancillary issues that go there with. Chet, are you on right now? I see you, yes, in the upper right corner of my screen.
I am, thank you.
And is Erica with you too? Yes, there's Erica.
Hello.
All right, thank you for being on, and I am going to go on mute and let you guys start with what's happening with forcible entry and detainer actions.
Great. Thank you, Thad, for the introduction. And my name's Erica. Chet's here with me. And
Erica, you need to come off mute. Or something's happening where we can't hear you, I don't think.
uh-oh. Are you not? Can you hear me now?
I can hear you.
Okay. All right. So,
I can't hear you yet.
all right.
Now
Erica,
Chet's on mute.
I
I don't
think
know
she's having problems because
if we can hear him, but Erica, I can't hear you.
Yeah,
can hear
I
her.
can hear her fine. I think it might be a problem with your speaker.
Yep.
Or your internet connection.
Oh, someone else can hear Erica. Okay, maybe it's just.
Yeah. So I'll get started. Maybe Angela can help Thad figure out what the issue might be. But if for some reason you stop being able to hear me, everybody start waving your arms and I'll know. So, well, thank you all so much for inviting us here to talk a little bit about how the forcible entry and detainer process has changed. Many of you might be familiar with forcible entry and detainers, but for those that aren't, that's what we call our eviction process here in the state of Maine. Sometimes we call those FEDs for short, and we kind of slip into that shorthand real quick. So, you know, it's been an interesting time, like as I'm sure it has been for all of us. The landscape has changed a lot. We've got a few executive orders that have changed the way that evictions are being handled. We have implications from the Federal CARES Act, and then the judicial branch pandemic management orders also affect this process. So what's been a pretty consistent process in the entire time that I've worked at Pine Tree Legal has now changed a lot. It's made it Really interesting to try to advise our clients. I'm sure many of you are in the same boat, whether your clients are tenants or their landlords, trying to help people understand all of the different implications of what's going on and how things are going to play out has been a real challenge. So we're going to try to outline, Chet and I, some of the orders that are affecting things and what the court process looks like, and also talk to you about, what you might have been hearing about in the media, this wave of evictions that's expected to happen as a result of the pandemic. And then also talk to you a little bit about ways that you might be able to get involved and help out. So I'm going to talk first about both the CARES Act, and there's 2 executive orders that have affected the process. And I'll start with the CARES Act because in terms of a timeline, that's the first thing that came into effect. So the CARES Act has what we've been calling an eviction moratorium provision. The CARES Act took effect at the end of March 27th, 2020. And what the CARES Act said is that for any property that's a covered property, and I'll talk a little bit more about what that means in a few minutes, but for any property that is a covered property and affected by the CARES Act, there was a moratorium on evictions that were based on non-payment of rent. And it's just that kind of eviction, only evictions that were based on the rent not being paid. The moratorium is for 120 days, and so that moratorium ended July 25th. Not only was there a moratorium on evictions for non-payment of rent, but the CARES Act also provides that a landlord cannot charge fees for late payment of rent during that moratorium time. And what the CARES Act says is that after the moratorium ended, which again was July 25th of 2020, that a landlord at that point, a landlord of a covered property at that point could give an eviction notice for non-payment of rent, but it had to be a 30-day notice. Regardless of what the lease might have said or what other state law might have been in place, it has to be at least a 30-day notice for that non-payment. And this applied for any covered property, and that meant under the Act, what it means is any property that participates in a program that's covered by the Violence Against Women Act. But a much simpler way to sort of conceptualize it is any property that involves a federal subsidy in some way or another. And that could be a Department of Housing and Urban Development federally subsidized property, like you might think of your typical public housing authority, for example, Bangor Housing Authority or the Portland Housing Authority. It also applies for any other kind of federal subsidy type of program. So there's also rural development subsidies. There's also private landlords who accept a voucher program that's federally subsidized. So that could include the Section 8 program. So it could be a private landlord who has a tenant who has a Section 8 voucher, and that's a federal subsidy. The Violence Against Women Act applied, and so this moratorium applies as well to those folks. And then also, there's also a provision that applies to private mortgages, multifamily properties that have a Fannie Mae or a Freddie Mac backed mortgage, so a federally backed mortgage as well. And again, same thing, no eviction for non-payment of rent or charges for late fees while a forbearance on that property was in effect. And so those are the covered properties under the CARES Act. Once that time period was up, July 25th, the landlord had a right to give an eviction notice for non-payment of the rent, had to be at least 30 days. And so now that we're at the end of August, we would expect to start to see some of those coming into court now that that 30-day period is up. So the other thing that's coming into play here is the governor's executive orders. And there were 2 executive orders that were issued. The first was issued in April 16th. And the executive order said a couple of things. One, it said that no landlord could try to evict someone by a means not authorized by statute. So no illegal evictions. Of course, that's already in our state statutes, but the executive order sort of instructed law enforcement under the guidance of the Attorney General's office that gave them the ability to enforce that provision. The executive order also said that no writ of possession that had been authorized in an FED action prior to the court shutdown could be served, either for the length of the order or until the state of emergency ended, whichever was longer. And it did give a limited set of circumstances under which a landlord could petition the court and ask for the ability to serve that writ of possession. And so there were some of those actions. There were some landlords who filed petitions with the court to ask to serve the writ of possession. But generally speaking, most folks who had, most landlords who might have gotten a judgment or a writ of possession in court prior to the court shutdown were prevented from serving that writ during the course of that order. That executive order also talked about the notice periods for a tenant at will. And a tenant at will is somebody who does not have a written lease, so they may have a verbal agreement to rent. And our state statutes lay out the notice periods for that because there's no lease, there's nothing in writing. And so under the governor's executive order, the notice periods for a tenancy at will, for a 7-day notice to quit that would have been based on non-payment of the rent, the governor's order said that had to become a 30-day notice. So instead of just giving the tenant a 7-day notice saying you have to pay the back rent that's owed or vacate in 7 days, had to be 30 days. And then for a 30-day notice, it said that that had to become a 60-day notice. And that order was in effect until August 3rd. So the governor's second executive order was issued on July 30th. And it sort of simplified things down a little bit. First of all, it repealed and replaced, as of August 3rd, that first executive order. And this executive order said that same provision about illegal evictions, no landlord can attempt to evict somebody by a means not authorized by court. And again, gives law enforcement the ability to sort of take some action to enforce that. And then it also simplified the language around a termination notice for a tenancy at will. And it said that if a landlord wants to give a 30-day eviction notice to a tenant at will, no cause notice, that now has to be 45 days. And for a 7-day notice to quit for non-payment, that again remains at 30 days. And so that order is in effect from now until either it's repealed or the state of emergency ends, whichever is sooner. So those are the orders that are sort of affecting right now the eviction notices and the eviction cases that we may be seeing. I will point out that under the governor's executive orders, those extended notice periods only apply to somebody who's a tenant at will. And so if somebody has a written lease with their landlord, the governor's orders don't impact that at all. They also don't impact somebody who's renting in a mobile home park. It's actually a different set of statutes, and the governor's order is very specific about the tenancy at will statutes. So those are some people that tenancies haven't been affected by the governor's executive order at all. And I think Chet's now going to talk to you a little bit about how the court process has changed, because that's the other thing that's happened is that under the court's phased management reopening plan and the pandemic management order 6, the entire court process is looking a little different than it used to.
Now, Erica, before Chet comes on, I just
Sure.
had a question. If you could sort of maybe reiterate it if you think you've already answered it, and that is, I believe our state of emergency is coming to an end on Friday, and unless the governor renews it. So if the governor doesn't renew it, so what does that mean in relation to these executive orders? Because I know some of them, it seems like some executive orders extend periods beyond when our state of emergency ends. But what is it that's going to change for landlords at that time?
Well, the current order, the one that took effect on August 3rd, it says, this order shall take effect August 3rd, 2020, and unless sooner amended or rescinded, shall expire upon termination of the COVID-19 state of emergency. So if, in fact, the state of emergency is not extended, then I think a landlord from that date forward would not have to comply with the executive order if they were, for example, issuing a notice to quit to a tenant at will.
Right, but what about the CARES Act, though? Is that officially done today, or did that get, is that affecting us too?
So the one piece of the CARES Act that doesn't have a sunset provision is that section that requires a 30-day notice to a tenant for non-payment of the rent. And so
Okay.
there is the moratorium itself that said you can't issue a non-payment notice whatsoever, had a sunset provision for the 120-day period. And so that was the end of July. But if you sort of parse out the CARES Act, I think the part that doesn't say that it expires as of July 25th is the part that says that a 30-day notice is required. So what's tricky, of course, about all of this is we don't have any case law to point to. And so I think, you know, it's going to be, the courts are going to probably be facing some situations where a landlord and a tenant might, in fact, interpret the CARES Act differently. So I think it's going to be interesting to sort of see how that's all going to pan out.
Thank you, Erica.
Yeah.
All right, we're excited to hear how the courts are going to interface with this, Chet.
Great, happy to provide a little background on that. Just by way of a little bit of additional information on the CARES Act moratorium, some of the mortgagees or the entities that insure some mortgages in Maine are setting out their own sort of moratoria. HUD has suggested that, at least issued a new mortgagee letter that may impact the eviction process, as has the administrator for Fannie Mae and Freddie Mac, but those require their sort of own analysis, but they're things important to look at. So the court process, just by way of background, most of you are probably familiar with the way the process once ran, and the way the process was operated is the plaintiff would serve a summons and complaint with a return date. And on that return date, the court would suggest mediation to everybody, and those who wanted it got it the same day. And whether or not mediation resolved the case went to a hearing. If it wasn't resolved, the same day. So everything happened on the return date that was set out in the summons complaint. That process has now been changed fairly dramatically. And so now under the Management Order 6 issued by the court, there is a mandatory required status conference that is held telephonically. And I'll run through real quickly the process and then come back and talk a little bit about some of the additional things the court has done. But beginning back to the status conference, the court will hold that telephonic status conference, and if it deems appropriate, refer the cases to mediation. In our collective experience so far, most of the courts are referring the cases to mediation. If mediation is successful or fails, the case will be settled, obviously. If it fails, it will be set for a hearing. And they're, generally speaking, the process is pretty uniform: status conference, mediation, final hearing. Our collective experience across the state at Pine Tree is that the mediations could be held the next day from the status conference, or could be scheduled a week later. I've got one right now that was scheduled 2 weeks after the status conference. Hearings, likewise, could be scheduled within a few days, but typically a week or more after the initial status conference. Interestingly, the summons and complaint, obviously now, instead of a return date to what court you're going to go to, it tells you what date you got, what time you got, and the telephone number you need to call in for the telephonic status conference. And typically speaking, but not always, the courts are then issuing subsequent orders for the mediation date or the final hearing date. I've not yet done a mediation. Some of our staff have. Some of the staff have reported they're pretty interesting. They provide a more meaningful opportunity for resolution than in the past. They're often set for about 30-minute increments. Whether that will be enough time in all these cases or not, we don't yet know. And whether or not, if it's not resolved, if there'll be additional time allowed, is also an unknown. The hearings are all in person under the PMO 6. It's presumptively in person, which is contrary to a lot of the other court hearings that are being held. But the parties can ask to have the court hear the hearing remotely, either by agreement or by motion of one party, and the court needs to make its own determination whether it's appropriate or not. We have heard, and I don't know what other experiences have been, we've had sort of a mixed record about safety during the court appearances. In some courts, things have gone really smoothly. Managing social distancing has been pretty good in the courtroom and in the hallways. The marshals have been pretty aggressive in ensuring compliance with the safety protocol. And in other courts, it's more complicated, more difficult. The courts are smaller, the hallways are smaller, there's less space to meet, there's less space to have confidential conversations. It's more likely you're going to be forced into a confined area with the opposing party. But there's a lot of effort right now in trying to resolve those challenges. And I think from our perspective at Pine Tree, I think we commend the court on pretty quickly rolling out this management order and ensuring that the process is fairly standard across the state. So we're seeing very similar processes being used in every court. And I have to say that under the original process, things varied with some regularity from court to court in terms of how things were done. But here it's gotten much more uniform, much more quickly than I would have expected. That I think is in no small part to the management order and the effort to try to get out some standard forms to all the clerk's offices, not the least of which is ensuring that the summons set out the appropriate call-in contact information and date and time with an instruction sheet, which is new. And that instruction sheet is attached to the summons complaint. It's intended to inform the parties of what the process is going to look like, giving them a heads up of what to expect, which I think has been really helpful and really informative to all the parties involved and allowed more uniformity. I think there's been a little bit of challenging moments in the beginning of these conference calls for the status conferences. If the judge isn't on or a clerk isn't on right away, the parties are sort of lost about what to do. They're not sure if they have their own hearing set up. They're surprised to hear other people on the phone waiting for something to happen. But that kind of little bit of clunkiness, I think, will resolve itself as everyone kind of gets more comfortable with the process. Thad, did you have a question?
And Chet, I was just thinking we're kind of running out of time here.
Got
I
it.
wanted to make sure in the takeaway I wanted to just throw in there, if it sounds right, is the courts aren't giving us dates anymore. We actually, right? That's been my experience. You actually have to file the FED, then you get that conference, and then they'll eventually get you a court date from there. Is that right, Chet?
That is generally speaking what's happening. And some courts are getting a hearing date announced at the status conference for those cases going to hearing, but typically speaking, it's by notice. There'll be a subsequent notice issued by the court advising of the hearing date.
And Chet, was there any other alibis for you? Because I wanted to hand a question over to Erica, and then I wanted to wrap up somewhat on time.
I have a question for him since he's speaking right now.
Okay.
Are all of the courts issuing new subpoenas for FEDs, disclosures, and contempt subpoenas without return dates?
So there are no disclosure hearings happening yet. For FEDs, all the summons have a return date for a status conference, but not a final hearing date. So if that's what you were asking, Angela.
That was a question that was posed. And then if someone's already sent out subpoenas with a return date, do they have to reserve a new subpoena?
In terms of witnesses and so forth, if folks are trying to subpoena witnesses to a hearing, you can't probably do it until you've got the actual final hearing date scheduled, and that will be based on what the court issues. Usually, almost always after the status conference takes place. But I've not asked that question during a telephonic status conference with the court about arranging for witness time.
Right, because I don't think we get a court date until that status conference at best. Yeah.
That's right. That's right. The return date on the summons complaint is only for the telephonic status conference. All other dates will be set by the court subsequent to.
I think there were some eviction cases that were served during the court shutdown period, and some of those summonses had on them date to be determined. Our understanding from the court was that they were going to reserve those summonses and advise people about what the date would actually be. So anybody that got a summons for an FED that said to be determined should be, or already has gotten a notice from the court saying this is now the date.
All right. And
Erica, you saw those other questions that were posed?
Yeah, Erica?
Yeah.
Yep.
So there were a couple of them, I think, if I can bring the chat back up. One of them was about, is there a distinction under the CARES Act between residential versus small business? And I guess what I would say is, I think the only distinction would be the CARES Act moratorium applies where there is some federal subsidy attached, where the Violence Against Women Act would be applicable. So I'm having trouble kind of thinking of a situation where that might be a small business. I suppose that's possible, but that would be sort of the question you'd want to ask on that.
All right, go ahead.
The other question asked if the CARES Act has a severability clause.
So I don't know that there is a severability clause in the CARES Act, although I don't know that I've read it searching for one either. Chet, do you have a different impression?
I don't, Erica, no.
Yeah. So I guess we don't have a great answer for you on that one. And then somebody else asked, can a writ of possession be served now? So yes, the governor's order that repealed and replaced the first order took effect August 3rd. And so in the governor's most recent executive order that took effect August 3rd, there's no provision that prevents serving a writ that was previously obtained. So then I think the only question is whether or not some kind of tenancy has been reestablished, or is there some other legal basis that makes that writ not valid? But certainly the governor's moratorium on serving the writs, that has now ended.
Thank you very much, Erica. And thank you, Chet. I appreciate you joining us and giving us some real good insights on the CARES Act and FEDs. Angela, I know we just wanted to give about 30 seconds to updating our business side. Angela, can you do that for us?
Sure. Most of this stuff has been up on the last couple of times we've talked, but it's more of a reminder. It says online membership renewal opens tomorrow, September 1st. Well, we have had a glitch in the matrix, so to speak, and apparently it opened yesterday. But it is up and running and officially opens tomorrow. But I think if you try to go online today, you'll be asked to update your membership renewal. But more importantly, I just wanted to point out that Karen Staples, who'd been working with us for about a year and a half, has left the Bar Association. We will miss her. She's been offered another job and took that opportunity. And we are sad to see her go, but we're happy to report that we were able to quickly hire someone else who's been in the Maine's legal community for many, many years for the membership services coordinator position, and that's Molly Rogers. You might recognize the name. She is Jackie Rogers' daughter-in-law, and she's been working she's worked at the Board of Overseers, she's worked for Walt McKee, she's worked in the district attorney's office, so we're very happy to have her starting September 14th.
Excellent. Thank you very much, Angela, and thank you everyone for joining us today. We will reach out, not next week, because next week is Labor Day. We're going to be taking that day off. And
yes, thank you, Thad. I forgot.
Roger that. But we will be reaching out to everyone on the 14th of September. Look forward to seeing you then. Thank you.
Thank you, everyone.